All right, willkommen, bienvenue. This is Translation Contracts 101 with the Authors Guild. Thank you for being here today. We're happy to put on this educational webinar for anyone who needs it. The Authors Guild reviews publishing contracts, including translation contracts. We also advocate for fair contracts for translators. We'll get into that more plenty, of course. I'll say now, though, we've got a literary translation model contract online that is publicly available for writers, agents, publishers to refer to for what we see as the ideal contract. And we're going to get into the weeds and also have plenty of Q&A time to answer your questions here. Our speakers today are the esteemed legal staff of the Authors Guild. Umair Kazi is the Director of Policy and Advocacy at the Authors Guild. He studied law at the University of Iowa and creative writing at Columbia University. Previously, he was a board member of the American Literary Translators Association and now an at-large advisor to ALTA's board. Kyle Maxey is a staff attorney at the Authors Guild. He studied at George Mason University and law at George Mason and political science, history, and business administration at Mount St. Mary's University. Umair and Kyle, thank you for doing this today. I'll go ahead and turn my camera off, but to the audience, we've got the Q&A box. You can enter questions there at any time. And before I forget, thank you to the National Endowment for the Arts and donors to the Authors Guild Foundation. That support lets us put on free public educational programming like this to whoever needs it. If you're not a member of the Authors Guild, go to our website, authorsguild.org, to learn about contract reviews and legal advice we provide and other members' benefits. With that, Umair, I'll turn it over to you. Thank you.
Thank you to the NEA. I hope you survive. Well, thanks everyone for attending this webinar, Translation Contracts 101. Just looking at the list of attendees, and honored to have worked with several of you. If you know me, I've been involved with translators, translation, literary translation for a while. And I really, it's a really interesting area to me, both, personally, because I also translate, but also professionally. And I really personally value translators. I read a lot of books in translation. So it pains me as much as you when I discover that publishers are not doing right by our brave and esteemed literary translators. So today, what we'll do is we'll go through our translation model contract, which I'm sure many of you are familiar with. If you're not, I would recommend that you I'll post the link to it in the chat, and I would recommend that you familiarize yourself with it. If you've never seen a literary translation contract, this would be the place to start. This contract was developed with a lot of really invaluable input from our translators group, a lot of counsel from actually working translators, and we're always working on improving it. There's some areas of translation that we, have talked about, but haven't quite figured out how to sort of frame in an advocacy sense. And by that I mean primarily word rates, because there's a lot of variation in terms of what publishers offer and from what languages they offer. And because we don't have collective bargaining in this country, even though we're trying to push forward on that, there are concerns of antitrust lawsuits if, say, we come out and say, here's a mandatory minimum that translators ought to get paid. But, as with, there are shared resources that the community has, created. Talk to your peers, talk to us. We can give you some guidance on what you can expect if you have a contract in terms of payment. But we can talk about that a little bit more. But let's get into this. I'm going to start with section 1. Oh, someone asked me to speak up a little bit more. So I will try. Is this better? Just type in the Q&A or chat if this is, if
That's
you can
good.
hear.
That's louder. Yeah,
Okay.
if you can just be a
Okay.
little
All
closer to
right.
the mic. Thanks, Umair.
Okay, perfect. So the first section we're going to cover is the grant of rights, and I'm just going to preface this by saying that as a translator, you are the creator of a translation, and you have the full scope of copyright rights that exist for any creators. So these are the exclusive rights of distribution, publication, or licensing, or creating. Um, I'll move a little bit forward too, and because I think there's still some volume issues. Is this better or okay?
I think,
Well,
yeah, that's
if
good.
yeah, if there are, just just flag me in the Q&A, and I'll try to figure something out. Maybe like put on my mic headphone. So yes, so translators are creators. They have the full scope of exclusive rights under copyright. And unfortunately, the practice for a lot of years in the industry had been to see translators as performing kind of rote function, and which is why publishers would often give translators contracts where they would ask for a full assignment of copyright, or they would be work for hire contracts. The work for hire is a specific special provision in copyright law. It's essentially means that the commissioning party is considered the author of the work, and it arises in two situations. One is where the work is created in the course of an employee's employment for the employer, and the second is if a work is specially commissioned and it falls under 9 enumerated categories, of which translation is one. So which is why we often see publishers offer works for hire contract. I mean, I see publishers offer works for hire contract for things like novels too, but that cannot legally be a work for hire because it's not one of the 9 enumerated categories in the Copyright Act. So with that kind of premise, I just want everyone here who's a literary translator to understand what it means to be a copyright owner. Copyright is a bundle of rights, and what that means is when you contract, you can carve out exactly the kind of rights you are granting the publisher. Now, in typical publishing contracts, the rights that you grant are the right to publish the work in enumerated formats. Typically, it's ebook, paperback, hard book. A lot of translation publishers actually don't publish hardback copies, but ebook customarily. In some cases, the publisher will also ask for audiobook rights, but I don't see it as as uh, as as a as often. So if you look at the clause one of our model translation contract, it tells you how to sort of put limitations on the publisher's grant of rights. And you'll see that it's got language that cabins what the publisher can and cannot do um, by by formats and territories. A lot of times, I mean, I'll talk about territories a little bit because it's very germane to how translators work, especially they work across the Atlantic. The in a Most publishers will ask for world rights, which means that they can publish the translation in any country of the world. And some publishers will also have in their contracts the language that says in any language in any country of the world, which essentially means that the publisher could use your translation to license a translation in Spanish and publish a Spanish translation in Spain or other Spanish speaking territories. So it's very important to one limit if you see language that says any language, to limit it to the English language and to limit it to ideally US and Canada. What that will do is that it will allow you to have the rights to separately license the translation to a UK publisher. Now, this doesn't happen very often. I will say that most publishers will ask for world rights, and we'll talk a little bit about how you get around that. Even if you grant world rights, what can you do to make sure that you're not getting shortchanged on the UK deals, and you're getting something from that? Because a lot of times what happens is it works both ways. It's a publisher in the UK may acquire translation rights or commission, or get a translation going, and then a US publisher will buy it. Sometimes, if a or sometimes it also happens that a small publisher publishes a book in translation, and the book blows up, and then a big publisher buys it. I think that happened to Knausgaard and some others, maybe Ferrante too, but so it's very important to look at that language. And I already discussed works for hire, territory formats. We'll talk about subsidiary rights now. When you in a publishing contract, there are two types of rights: primary rights, which are the rights that the publisher that you're contracting with exercises, and subsidiary rights, which essentially mean that the publisher can license certain rights in the work through another party. And these often fall under the concept of derivative rights. So, like I said and mentioned at the beginning, and translators should really, really be familiar with this concept of derivative work. So every one of the exclusive rights under copyright is the right to create derivative works or license that right to someone else. And a derivative work is essentially a new copyrightable work that is based on a pre-existing work. So a translation fundamentally is a derivative work of the original. Now, when the derivative work comes into existence as its own independent work, it also has an exclusive right to create derivative works. So a lot of the subsidiary rights that publishers ask for, are kind of um, uh, defined within the framework of derivative work rights, and those include, first serial rights, um, which is publication of an excerpt from the book, verbatim text electronic book rights. If a publisher is not making an ebook in house, they can license this out. Audiobook, anthology, and quotation. Oops, sorry, those are not. Those are the rights that the publisher gets. My apologies. I mean, subsidiary rights would be, well, they could also be subsidiary rights, but oftentimes subsidiary rights are the right to license dramatic adaptation of the work, or the right to create an enhanced ebook, an ebook that's not just verbatim text, but has other elements like animations and so on and so forth. And Kyle will cover that a little bit when we talk about royalties, how to sort of protect yourself so you're not giving up, a broad sort of broad swathe of your rights. Moving on to section 2, which is delivery of the work. This can be a little tricky sometimes because and I've seen situations where there are disagreements between publishers and translators on what is the acceptable delivery of the work. And you'll see in the delivery clause, we use the standard editorially acceptable. A lot of times publishing contracts will say, translator agrees to deliver us a final manuscript by a certain date, and we can accept, or it has to be acceptable, or and will I mean, some contracts actually do say that the publisher has a certain amount of time in which to sort of inform the translator whether the work is acceptable or not. A lot of times, this these details are not clarified in the contract, and it might just say you'll submit you'll submit a a draft to us, and we'll either accept or reject it. So you've put in all this work in the draft of the translation contract, so it's reasonable to sort of have some safeguards there. So one of the things that we suggest in that clause is to emphasize that the work will be editorially acceptable, which kind of creates an objective standard. And what we're trying to protect against is between the signing of the contract and the delivery of the work, there's that can be like a year or a year and a half, and the publisher at that point might determine that there's no market for the book, and they might use this acceptability language um to cancel to cancel your contract, and by that time you've put in so much work. So editorially acceptable means that if the publisher can only reject it if the translation is has so many editorial problems. It's not it's just not up to par. Um, and even then, we we say that you should require the publisher to give you um, specific feedback on what it finds unacceptable about your manuscript within 30 days of delivery of that manuscript. A lot of times, translators submit sample translations before and in that case there's the publisher already knows how good the translator is, so there's no real reason for them to sort of like have another acceptability standard. So we say if the publisher has asked the translator to provide a sample translation prior to the signing of the agreement, the phrase editorially acceptable will be defined as the standard of the sample translation submitted prior to the execution of the contract, which just means that that the publisher has already reviewed your work, and if the final manuscript falls way below the standard of the sample translation, the publisher can't reject your work. A lot of times I see, well, not a lot of times, I mean, sometimes I see contracts say that the publisher will get the author has to approve the translation. We advise against that language. Authors, the translator knows what a good translation is. Authors often don't know what a good translation is. That can create like unnecessary conflict between the author and the translator. So we also have a, a clause relating to translators' use of AI just to protect translators. If a publisher asks you to use generative AI or work from AI generated text, they you can say no. So that's what the clause does. And even in the grant of rights clause, we have a clause. We've added a clause that um, uh, you can use to prevent the publisher from licensing the translation for generative AI training uses. So moving on to editing, again, sometimes this fairly innocuous area of a publishing contract can become very contentious. Publishers, I've seen situations where publishers edited the translation so much that it had a totally different meaning. So uh so that's why it's important to sort of limit what the publisher can do to the translation draft. And we say that the publisher agrees not to make any changes to the translation except for copy editing to conform to the publisher's standard style of punctuation, spelling, and capitalization, and no other changes may be made without the translator's approval. um the translator gets 30 days to review the copy edited manuscript. And then there is a proof stage where the publisher will send the final proof, page proofs to the translator. Now, a lot of times, in making any changes to the proof costs more. So publishers will say, if you make changes, then you'll pay for it. Most of the time they're reasonable. The model contract has language that is typical, where the publisher says that if the translator makes changes to the proofs that are above the 15% of the original cost of typesetting, will be paid by the translator. So that kind of creates a ceiling for which the translators for the amount of money the translator is responsible for. Let's see. Let me just see if there are any specific questions to the three areas that we've covered. Um, okay. Don't see it. We will answer the questions as we go along. Kyle, do you want to take on and start talking about fees and royalties?
Yeah, sure. Yeah. Yeah, so just want to say hi, everyone. I'm Kyle. I'm a staff attorney at the Authors Guild. I am not a translator, but I've been working with Umair on these translation issues for almost 3 years now. So I'd like to think I have a fairly good understanding of it. So basically, with fees and royalties, they kind of vary widely by contract, by translation contract. And looking at Section 4 of our model contract, there's two main ways that we see. Normally, I would say probably the most common one we see is a fee, right? Usually that's based on word count. Um, However, we recommend that you try and negotiate a fee based on the word count of the original work, not necessarily the work that not necessarily your translation. Oftentimes the original work's word count will be higher. And you also want to take into account the estimate of how much time it's going to take you to translate, the difficulty of the text, really any other factors that will be in that. Um, the other thing you would want to notice, you'd want to take into consideration is too, is you really want to try and negotiate for this fee to be as high as possible, especially if you're not going to be receiving royalties. I mean, this might really be the only income you see from creating the translation. So ideally, you would want this to be, as high as possible. We always recommend that you try and negotiate for royalties as well on the number of copies of your work that are sold. Um, Now, I will say these are a lot smaller than they are for traditional publication contracts. And a lot of these translation contracts will essentially treat the translator's fee as an advance, right? So you won't earn any royalties until you pay out that advance. If that's the case, you can try and mitigate this by either, again, asking for a larger fee up front, or asking for the royalty payments to start before the advance is fully, or before the fee is fully earned out. Um, as Umair said, yeah, because there's no collective bargaining, we generally can't recommend uh, uh, prices, but these are what can't recommend royalty rates, but this is generally what we see. We generally see 2% of the list price on all print copies that are sold. And that's for hardcover and paperback. Now, Umair said yes, most of the times they won't do hardcover, but regardless, you would still want to make sure that it's the same rate for both, so that way your publisher can't get out of paying you uh, by essentially choosing the cheaper version for them. We generally see 5% of the publisher's net receipts for the sales of the electronic edition, and then it's generally 2% across the board for audiobooks. And as Umair said too, the last real piece in the fees and royalties section of our publishing or our model translation contract is subsidiary rights, right? So Umair touched on what these are, and generally, we recommend that you reserve these rights for yourself. And if you can't, what you would do is ideally, grant them for a period of time to your publisher, and that way, if they don't end up using them within that time period, they revert to you. Now, if you do grant them, as Umair had mentioned before, you really want to make sure that you have you're getting your fair share of these rights. I mean, these can be a much larger share, and you will end up getting a much larger percentage than you would under traditional royalties, right? So generally, we like to see your share from subsidiary licenses to be 25%. So that would be 25% of whatever the publisher is bringing in from licensing your translation. And again, that might be, serial rights, that could be anthology, that could be really any of these rights. That are actually, that I would say are more prevalent than I would say, you would think. And again, even if you think, well, this might not apply to me. I mean, you'd rather be safe. Our views, you'd rather be safe than sorry, and have that right to have that rate in place, so that way, if you do end up licensing these rights, then you will get adequately paid for them. Let's move on to publication, section 5. So this section really deals with making sure that your work is published on time. And generally, we like to see that there's a deadline inserted into the contract, so that way your publisher has to publish your work within this time frame, or they forfeit their right to do so. And ideally, that's 12 to 18 months after you deliver the translation or after the translation is accepted by your publisher. And again, if they don't publish within this time frame, you should be able to. They should essentially forfeit the right to do so, and you should be able to keep all the monies that they've previously paid to you. Now, there will be clauses in the contract that try and stipulate that, if there's circumstances that are out of the publisher's control, that the publication deadline can be extended. Now, again, we recommend that you try and delete these types of clauses. Will publishers actually do it? Probably not. So what we really recommend is you either try and ask that they make this the same circumstances beyond your control language applicable to you as well. Or if they're not going to do that, you really want to try and limit the conditions to, force majeure type, act of God type things where, like war or riots, natural disasters, those types of things, not necessarily strikes or material shortages. And even if you do limit it, we really feel that a publisher really shouldn't be allowed to delay publication for more than 6 months past the original deadline. Just to be fair, and that way your publisher can't essentially sit and squat on your rights and without publishing your work. Actually, we're gonna go to warranties. Actually, that's section 7. So generally, warranties are promises that you're making about the work that you're delivering to the publisher. And generally, publishers are going to be very reluctant to negotiate these provisions. But really, if you're able to do so, we'd like to insert the language to the best of the translator's knowledge before any promises you make, especially those pertaining to defamation and obscenity laws, and also permission to publish the work. Legal standards for defamation and privacy and obscenity laws are very difficult, and it's going to be impossible for really any writer, translator, anyone really to state with absolute certainty that the work does not violate those laws. And further, since you're not the author of the original work, you ideally shouldn't be the one warranting that the work it doesn't violate these standards, right? Really, you should only be warranting that the translation is faithful and that you did not include anything extraneous that would be considered infringing or defamatory, right? I.e., essentially that you didn't introduce anything that was not already present in the underlying work, right? I mean, that's the best case scenario there. And really, your publisher should be the one that has to warrant that they have permission to publish the work from the original author. You shouldn't be the one that has to warrant that. Along with that as well is indemnities. That's not a separate provision in our contract, our model translation contract, but it is important, and it goes along with warranties. They're kind of I guess siblings in that way. Now again, keep in mind that publishers are going to resist making changes to these types of clauses, but essentially, where this comes in is that publishers might ask you to warrant that you would indemnify them in case anything happens in terms of lawsuit or legal actions or breach of contracts or anything like that. I mean, in our mind, again, you're not going to be able to completely eliminate those, but you can try and, I guess, mitigate them in the following ways. One, you can try and stipulate that you're only going to be required to indemnify your publisher if there's some sort of final binding judgment, not just a lawsuit, not just the threat of a legal action, really only if it's a final binding judgment. Number two, you could try and insert a cap in the amount that the publisher may withhold or recover from you if you're found to have breached the warranties. Number three, you could require your approval over any proposed settlement before it's actually settled. That way, the publisher doesn't, settle and I guess agree to something ridiculous that you have to pay for without your knowledge of it. And then finally, you could try and get coverage under the publisher's liability insurance policy. And again, they might not agree to any of these, but it can't hurt to ask. I'm going to move on to section 8 now, which is accounting and royalty statements. So, this is extremely important, especially if you're going to be receiving royalties. This is very important. Understanding how and when you're going to get paid is by far one of the most important parts of your contract. Ideally, you'd like to get royalty statements either biannually or quarterly, and that would be, and you'd receive those within 3 months of the close of the given accounting period. Even if your publisher, and we've seen this a lot in translation contracts, where they will have a threshold where you must hit before you're able to receive your royalty payments, right? So let's say it's $50. You have to hit $50 in an accounting period of royalty payments before you're able to be paid. You should still get a statement, even if you don't get payments. That way you can still check your accounting and see what you're earning rather than just taking your publisher's word for it. Another common feature, and I know that we had a question about this, was reserve against returns, right? So essentially what that means is your publisher will have the ability to withhold a certain amount of your royalties in the case that your work is returned, right? In the case that your translation is end up returned, right? So again, generally speaking, you're not going to be able to get them to delete this entirely. Now, again, you can try and mitigate it in one of two ways. One, you can try and reduce the amount that they're able to withhold from you. Generally these contracts will just say a reasonable reserve against returns. What does reasonable mean? That's not entirely certain. So it makes more sense to set an amount, and that, ideally that would be 15% of the amount due to you. But we publishers may not be willing to agree to that. So it's really a matter of negotiating. And the second thing you could do is make it so that they can only withhold a reserve against returns for the first 3 accounting periods that you do. So essentially, it can't be indefinite, and essentially get out of paying you that amount. Another thing to keep in mind with accounting and statements is what's called a cross collateralization clause. This is essentially a clause that ties multiple works together into one financial venture. And you generally don't want to do that. Each work should be its own financial venture, right? So normally this language will state, under this or any other agreement. If you see that type of language in your accounting or statements clauses in your contracts, you generally want to try and delete that. That is, we hold the view that they should each work should be a separate financial venture on its own, and they should not be tied together like that. Uh, I guess I'll move on to the audit clause at this point. So audit clauses are extremely important, as well as, and I know I'm going to say extremely important a lot. I think all these clauses are extremely important, but audit clauses, they might be the only real way to understand whether your publisher is correctly calculating your royalties or not without bringing a lawsuit, right? So generally these allow you to hire an auditor or have some other representative of yours audit your publisher's books to make sure that their records that they are paying you the correct amount of royalties, right? And again, these are extremely important because if your publisher is not paying you the right amount of royalties, or you think that there's something wrong, this will give you essentially a look under the hood. And ideally, you would want to stipulate that if your representative or whoever carries out the audit discovers an error of 5% or greater, the publisher shall pay for the cost of the audit. I mean, that's pretty fairly industry standard from what we see. And I'm going to move on to copyright now. So, as Umair said, and he hit this spot on the head. Translators do have copyrights, and I think that's one of the most important things that I have learned in this whole process as well, is that you have the full plethora of copyright protection for your translation. Again, this doesn't give you any rights to control the original work, right? But it does give you control over the translation, right? So first and foremost, you want to make sure that you always retain copyright. As Umair said, sometimes the publishers will structure the work as a work for hire agreement, or alternatively, we've seen where they just essentially assign the copyright to themselves and cut translators out completely. And again, that's the exact opposite of what you want to do. Them cutting you out completely essentially makes them the translator and the owner of your work, and essentially gives them all the benefits while you're cut out. And I think that's just something, that's you have to keep control over that. And because if you don't, then again, your work is essentially not your own anymore. And the control of it goes to the publisher. Along with that, you should, while registration is not required for copyright protection, it's highly recommended that you register your work, and we ideally like to recommend to our translators that your publisher register the work, register the copyright in your work in your name with the United States Copyright Office within 3 months of initial publication. That's because if you don't register within 3 months, you could lose statutory damages and attorney's fees in the case of infringement. So you really want to make sure that you're on that just in case. And then finally, you really want to make sure that the publisher and anyone they license the rights to are required to print a copyright notice in every copy of your work. Again, those are not required for copyright law anymore for copyright protection, but it does create a public record, and it is extremely helpful going forward. Umair, did you want to take the last few sections we have?
Yes. So, credit, it's pretty simple. I mean, it's simple, but it's tricky at the same time, because a lot of publishers, English language publishers, really resist putting the translator's name on the cover. So we really think it's an important advocacy point that you should emphasize in your discussions with the publisher. If the publisher, if the contract is silent, ask the publisher to include language that says that they will put your name on the cover and wherever the author's name appears. There was a big campaign that the Society of Authors Translators group started. There have been articles about it, how it's such a travesty that translators are often not named on the cover. Translator copies, in every publishing contract, there's some free copies that the publisher offers. In translation copies, I see, very low amounts, often like 5 copies. And these are basically copies that you can, give away on your own, or like, use at readings and things of that sort. So you should ask for at least 10 to 15 free print copies, and also include, if it doesn't already exist in the contract, a provision whereby you can buy additional copies for a 40% discount. That way you can have copies at hand if you do readings or events and that sort. Finally, one of the most important areas of the publishing contract is the termination provision. So if we refer back to the grant of rights language, oftentimes you'll see that the grant of right language says that the translator is granting rights throughout the whole term of copyright. Or the whole term of copyright is very, very long. The term of copyright is essentially 70 years after the death of the author or the death of the translator. So in that frame, if you sign if you agree to that language without having any termination or reversion mechanism in your contract, you'll never see your rights back, which means that you'll never be able to republish the translation. And I'll talk a little bit also about like what you need to republish a translation, but that's the case. So it's very important to have language that allows you to get your rights back if the translation goes out of print, or if the author's license expires. I'll quickly also mention a specific provision of the U.S. Copyright Act. It's called the statutory right of reversion. It's in Section 203 of the U.S. Copyright Act. And essentially what it provides for is any copyright owner can terminate any copyright grant between 35 and 40 years after the execution of the grant. So even if you don't have a reversion mechanism in your contract, be aware of this statutory right that you have to get your rights back. Authors do it a lot of times. It's used, the reversion rights it's used in film contracts where the author has signed a production deal and they cancel it after 35 years. So it's an important thing to be mindful of. Now, if you look at Section 13 of our model contract, we say that if the translation is out of print or unavailable for sale, there's a specific definition for what that means. The translator may send a written request to the publisher for the full reversion of rights. If the publisher fails to reissue the translation or make it available for sale within 6 months of the translator's reversion request, all rights in the translation and any other rights granted to the publisher herein will automatically revert to the translator, subject to any outstanding licenses still in effect, but no extensions or renewals thereof. So what this is saying that, and let's look at 14, 14, well, described in 14B. No, it should be 13B. I just noticed typo in our model contract that I'm just gonna make a note of. So 13B lays out few options for the definition of what it means for the book to be out of print or unavailable for sale. The most common one is that the translation will be considered available for sale only when print copies are available and offered for sale in the US through normal retail channels. That's kind of the standard one. There's what we recommend is you also put in additional language, because now a lot of publishers are using print on demand or ebook formats. So what that could mean is that a publisher is no longer has a print run and is not going to do another print run, but they can still hold on to your rights by licensing a print on demand version or an ebook version. So it's very important to sort of have some kind of kill switch for that. And if you look at that, that's options 2 and 3. Option 3 is the most favorable to the translator, because it conditions the reversion of rights based on a minimum amount of royalties that the translator gets in the most recent 2 accounting periods. There's also a clause 13C. What it does is that it prevents the publisher, well, it sort of obligates the publisher to keep the translation in print and not remainder it for within 2 years from first publication of the translator's agreement. And if the translation is terminated, the publisher pays the translator 1%. And then finally, I think the subclause D is very important to add, because the translation is essentially translation rights are essentially a Siamese twin of the author's rights. So the publisher can only publish the translation as long as it has a license from the author and rights from the translator. Oftentimes, the license from the author is limited. It might be for 10 years or 12 years. But the rights that the translator has granted to the publisher may be like full term of copyright. Now, when the publisher's license from the original author expires, the publisher can't, sell the translation. They need that license. So why do they need to hold on to the translator's rights for that long? But that happens. That happens most of the time, is that because translators don't know the length of the license term that the author has granted. That's a big kind of advocacy problem that we are addressing with, and I'll talk a little bit more about it after I conclude my remarks on the contract. But it's very important that you put in a clause which says that your rights come back to you when the author's contract expires. What that allows you to do is then communicate with the author, hey, your license expired. I have my rights back. Can we work together on republishing it? And that can't happen, unless you have your rights back from the publisher. So I just wanted to point that out. We also really recommend that you put in a clause which says that if the publisher defaults in the delivery of statements or making payments, or should otherwise be in material breach of material provision of this agreement, that your rights automatically revert to you. And this clause is important because what happens is, publishers will sometimes be in financial distress and they won't make timely payments or render statements. And then you'll hear that they're going bankrupt. And what that means is, as long as the bankruptcy process is ongoing, you can get your rights back. So what this clause does is it allows you to get your rights back if the publisher is not paying you, and make use of the rights in another way. So amendment is a simple boilerplate. It just says that both parties have to agree in writing to amend the contract, and then governing law is another standard boilerplate. A lot of times, we recommend, if you can, to negotiate, and it already is the case that most contracts are governed under New York law, where the jurisprudence on publishing is most evolved. So that's it for the contract. Let's get to some of the questions. I'll start with the questions that came in through email before. So the first question is, are quotes based on word count or estimated cost for translation research plus word count? I think Kyle already addressed this. There are different models. Many are based on per word count per 1,000 words. We recommend that you negotiate a flat fee for the translation based on the number of words in the original work and the time you estimate it will take you to translate it, taking into account such factors as significant research or a particularly challenging style. If you're doing word count, try to base it on the final, not the word count of the original text. Are there any considerations for contracting with regards to the use of work in Gen AI training? The model contract has clauses that restrict the publisher from licensing translations for Gen AI, and also to use AI narration or cover design in the translation. So this is an interesting one. Can you please advise how to get a better percentage of books that are held for return? Are they still practicing this policy? So reserve against return is when the publisher essentially holds back a certain amount of royalties due to you because of expected returns. And sometimes the contracts will just say we'll hold a reasonable reserve against returns without specifying what that means or for how long. So what we recommend is that you put some parameters around what that means, and we usually say no more than 15% of the 15% of the amount due in a royalty statement, and only for the first 2 accounting periods. Can you address translations of dramatic works? So the thing to know about translations of dramatic works is you first have to get the permission to translate from the author. So if you're just translating the text of the play, you have to get that permission. And then if you're publishing it, you also have to have permission to publish it. And that's because the permission to translate and the permission to publish are connected to 2 separate exclusive rights under copyright. The permission to translate is the right to create a derivative work, and the permission to publish is the right to reproduce and distribute copies, rights to reproduce and distribute copies of the work. So if you're publishing a translated play on your own, you need to get those both the permission to translate, permission to publish, or you just get the permission to translate and have the publisher get the permission to publish from the author. A lot of times I see that translators will just translate something without getting the author's permission and then try to shop it around. That's not really how you should do it. You're technically in infringement on the author's right to license derivative works. So if you really want to translate something for your own and then see if it'll get published, always reach out to the author or the rights holder. But for dramatic works, there's also the issue of performance rights. The right to publicly perform a copyrighted work is another separate exclusive right under copyright. So you can translate it, but any theater that puts on that work will have to get performance rights from the author. So could you talk about subsidiary relay translation rights? I kind of touched on this. Relay translation is essentially, a lot of times what happens is that, say, there's only like that a translation appears in English from a language that doesn't have that many translators to other languages, and a downstream language will use that English translation, or a translator, say from Spanish, will use the English translation to translate the work, not the original. That's called a relay translation. And our contract has language around that. You should be getting paid something for that, or reserve rights. Do you have any tips for effective negotiations when the publisher's initial response is a no to the changes you request? Yeah, just general things. I think the first thing that you want to do is, before you even get into the negotiation, is identify which changes are the most important to you and prioritize them, and sort of have like a firm line for what you will accept or not accept, and have kind of like a B and C plan. Like you start with like the most sort of ideal or optimal change you want, and then the publisher says no, then go back and say, well, what about this, or what about this, and kind of do it that way. If the publisher says no to something that you absolutely need in the contract, you can lean on industry standards. You can refer to our model contract, say this is what the Authors Guild is advocating for, and I really want this. This is in to the benefit of all translators. And if enough translators do it, then we do see kind of custom changing. Always ask for why they're saying no. Don't just accept their sort of their response. Okay, Kyle, do you want to take on some of the ones that you had, and then we can, maybe if we have time, we can turn to some of the open questions here.
Yeah, of course. Um, so I had a few that I was going to answer. So this one was just in case, how does one unilaterally get out of a contract? That really depends on your contract. Generally speaking, there's no real surefire way to unilaterally terminate your contract. If you have some termination language in your contract, that's great. If not, you're going to essentially have to argue that your contract's been materially breached, which could end up resulting in you having to take the publisher to court. And it really, the basic answer is generally you can't unilaterally get out of your contract. A second question I had was, what should be in a contract concerning the future creation of a film or TV show based on translation? Kind of as we said before, you really want to reserve these rights, if you can. I saw one question in the chat as well, was about, so essentially, would you split, if they made a film or TV show based off of the work, would you split it with the author? Well, it kind of depends what they write the screenplay off of, right? If they use your translation, then yes, you would get some portion of the royalties or something. But if they use the original work, then you might not. But essentially, yes, you want to make sure that you reserve these rights. And again, they ideally wouldn't your contract ideally wouldn't cover the creation of the film or show in detail. I mean, that would generally be a separate agreement, like a film option or a shopping agreement, something along those lines. What to do when your publisher asks for worldwide rights and all subsidiary rights? To what extent can you push back as a beginner? Now, again, as we both Umair and I stated, we recommend that you try and reserve these rights. And again, if you can't, try and grant them only for a period of years, by which your publisher must use them or essentially return them to you. We always advocate for pushing back with your publisher and asking questions. Kind of as Umair said, even if they say no, that's the worst they can say. And you're more than welcome to push back and just ask questions. It can't hurt, in our opinion. And if your publisher gets offended by you asking questions or asking for changes, then that might not be a publisher you want to work with. This one says, if you're already a publisher, do you need permission to have your work translated into Italian? Or if you're already with a publisher? Now, again, that depends. That depends on the rights you granted the publisher. If you granted your publisher specific language/translation rights, then yes, you would need their permission before you authorize the translation of your work in that language. You basically can't, if your publisher has the rights, you can't go exploiting those rights. And then finally, the last question I had was, if I received a translation offer on an indie book, should I find agent representation to help or try and manage it myself? So I think this can be broadly applied to translators as a whole. That really depends on your situation. If you feel comfortable without hiring an agent and you feel like you can do everything that they would do, then by all means, go forward without one. but they can be very helpful. They do come with a commission that you would be paying them, but they can be extremely helpful. And again, they do certain things that we might not necessarily be able to do. We can, for example, we can review your contracts, and we can give you, I guess, information and I guess pointers, but we can't negotiate your contracts for you. That's just not something that we do, but that's something an agent would do. Umair, did you want to do some of the? I guess, do we have
Yeah,
time?
yeah. Let's do some of them.
Great.
I tried to answer. So I will just finish answering this one. Okay, so let's see. We talked about acceptability. There's a question about that.
We've talked about ideal subsidiary rights situation.
Yeah, we've talked about that. We've talked about acceptability here. Oh, so yeah, I mean, just touching on, are you saying the translator shares in the original book author's film rights? That seems odd. So, it is kind of tricky, right? Because if the screenplay is being produced in English and your English translation is being used, then you are the one who would be granting film rights in addition to the author. The author is essentially granting film rights based on the characters, out of the copyright they have in the characters and the plot. And you are granting the rights based on the expression of the language. Now it's tricky. Sometimes, a producer may just get the rights to the film from a foreign language publisher or the author, and write a screenplay and then have the screenplay translated, and it is often not exactly clear, but an ethical publisher will reach out to the translator. I do want to clarify one thing that I said. So when I said get permission from the author, I should have said author or the appropriate rights holder. A lot of times, if a work is published and in print in a foreign language, the author may have and likely did grant translation rights to the publisher. So in that case, you would have to go to the author's publisher. This is not always the case. Sometimes, the author just like here, an author may reserve translation and foreign publication rights. But in most cases, especially if it's a popular book and with like a big foreign publisher like Galmard, the publisher may have the rights. And if the author is deceased, then the estate might have the rights. So you have to do a little bit of digging to figure out who has the rights. Sort of the easiest way to do it is if the book is in print by a foreign publisher, reach out to them.
I, I had one that I saw we could answer. It was essentially what happens if a publisher won't budge on royalties or higher fees or any subsidiary rights. So again, I think you could broaden that into what happens if a publisher won't budge in general. Again, it can't hurt to ask questions. If they say no and they really are dug in, that would become then a personal choice on whether or not you're okay with signing a contract with potentially some unfavorable or less favorable terms. I mean, again, that really is down to a personal decision. Umair, do you have any other ones?
Yes. So someone asked if you can put in reasonable time frames for pub date and response after submitting the manuscript. Very important. Yes, give them 60 days or to give you a response on whether they want to publish the book, and definitely have a pub date. Usually it's like, I think, 18 months after the delivery of the manuscript, but just have that. So because what happens, I've seen this happen, is that like a translator will sign a contract and the translation isn't published for like 5 years. And I mean, that's just unfair. Even if you've been paid everything for that translation, you want to be able to get those rights back and make something with it. We are pushing back on works for hire translation contracts. I think the more translators push on that and say that this is unacceptable, the more of a difference we'll be able to make. Yeah, this is really unfortunate that the publisher did not agree to put your name on the title. That's just, it's one of the worst things when they do. So really push hard on that. Registering with the Copyright Office within 3 months. At what stage is after publication, delivery, contract signing? So you can register at different points. You can register your unpublished work, and then when the and register again when the work gets published. The 3 month deadline is to get the benefit of statutory damages if your work gets infringed, and to be able to recoup attorney's fees from a potential infringer. So definitely register within 3 months of publication, but you can register before too.
Yes.
So I hear this a lot, like publishers will come back and say that they cannot offer royalties because they're giving the author royalties. And I don't think that's fair. I think our goal, and we're going to be talking to publishers soon, is to sort of convince publishers to have the translator's royalty in their calculations before they acquire rights. So to tell the author, but also like the publisher can pay the translator out of their own cut. So it's really important to push back on that. Right, I think we've answered.
I saw one more that I thought was interesting. Two kind of similar.
Yep.
One was about enforcement, right? I was just basically saying, how can we enforce these contracts? We can, if you're having a problem and you're an Authors Guild member, please, reach out to us. We will do what we can, and we'll try and intervene. And a lot of times that works. If not, yeah, I mean, you're right. It's tough, especially with overseas publishers. It's very difficult to sometimes enforce these contracts. But there are options, being, legal actions. And again, a lot of times when we get involved, these publishers will, hopefully, I guess, get back on track. And then someone else said, and Johnny, I don't know if I'm stealing your thunder here or not, but someone asked if we had questions that weren't answered, who could we email? You can either, A, if you're a member, fill out a legal help request, or B, you can email staff@authorsguild.org, and they'll direct your question to one of us. So.
Thanks. Yeah, this has been great. I was gonna ask about the enforcement too. That's tough, I'm sure. I'll pop that contract URL back in the chat again, and we'll email it out to everyone. Also, on Friday, we've got another translation-focused event. Our friends at Alta helped put it together, and it's basically a panel of publishers from the U.S. and Europe, and they'll just be discussing breaking into the field, managing your career, what they want translators to know about the market and about the whole process, what to expect in terms of the editorial and the launch and everything like that. We've got a great lineup for that. So if you haven't seen that, check your emails, and we'll have a reminder for that going out tomorrow. Yeah, and with that, yeah, contact the Authors Guild. The contact form on our website, if nothing else, that goes to the same email address, staff@Authors Guild, and we forward those around easily. So thank you all so much. Thank you, Umair. Thank you, Kyle.
Thanks, Johnny. Thanks, everyone.